Now we're going to discuss the last trial from this CRPC. We call it the summary trials. Uh, Frankly speaking, it's not trial because there is no such kind of procedure is provided. But since the title is provided under the law, we are going to discuss it under the title of summary trials itself. Section 260 to Section 265 deals with this aspect. There are only five sections are there, but frankly speaking, there are only three sections which deals with this aspect. Now, the title itself shows the summary, that is the gist. Under this, one of the characteristics of this particular trial is that there is no such kind of technical and lengthy procedure provided under this trial. The trial is based upon the very famous maxim that is called as justice delays, justice denied. And therefore, if the offenses for which the punishment is very less, of course, less than the 2 years, as it is for the summary trials, that particular matter, that PTPT matters has to be decided, and the court should not be overburdened by this small trial. This is the only intention of legislature by making such trials or inserting such trials in the CRPC. Now, uh, if you go through the provisions, and very simple provisions are provided, because the section 260 is the opening section of this trial. It says the power to try summary. Now, this is something new which we are going to discuss here, because of course the magistrate is going to discuss all these trials, that is summary trials, but it is not all the magistrates. Section 260 provides that only those magistrates which are specifically provided under section 260, they are empowered to conduct the summary matter and not the other magistrate. Who are they? Firstly, the chief judicial magistrate, he is empowered by section 260, and in metropolitan area, the metropolitan magistrates, I'm not saying chief metropolitan magistrate, but metropolitan magistrate. In other than metropolitan area, it's a chief judicial magistrate. Then in metropolitan area, metropolitan magistrate, and thirdly, any other magistrate of first class, that is we call it judicial magistrate first class. But it's not a full stop. They say specially empowered by the High Court in this PR. So if you go through the section 260, it simply says who are empowered to conduct the summary trial. The first one is the chief judicial magistrate, second one is metropolitan magistrate, and third category is the judicial magistrate first class, who is specially empowered by the High Court. There has to be some special grant from the High Court to particular judicial magistrate first class to conduct the matter. However, in one of the section, that is section 262, says even judicial magistrate second class is also empowered to conduct the uh, summary trials, but he cannot award the punishment more than 6 months. He cannot award that. This is what the characteristics of section 262 says. So by rule, if I'm sorry, 261 says by rule we can say it's a chief judicial magistrate, metropolitan magistrate, judicial magistrate first class, and under section 261, the judicial magistrate second class also empowered, but while conducting the trial, he cannot. He is not empowered. He is not empowered to the punish the accused person for not exceeding the 6 months, not exceeding the 6 months. This is what the another characteristics of the summary trial. Now this is the court empowered. Let us take the uh, which subject to which subject this particular trial is applicable. That is most important. Subclass 2 of the section 260 itself provided the cases for which the applicable. The first and most important, that the offences for which the punishment is not exceeding 2 years. This is the again uh, basic difference between other trials and this summary trials. So the punishment should not be more than 2 years. Then most important, say for instance the offence of like theft either by the ordinary person or the servant under section 379, 380 or 381. But it's not all the theft, because if you go to the definition of the punishment for theft, it's a 3 years, and therefore one of the provisions said not more than 2 years, but same another says it's a theft, but the theft for which the amount, that is value of the stolen property, if does not value more than 200 rupees, then it's tried summarily. It's not all the theft. Or in case of receiving of the stolen property, we have already discussed under section 411. If the value of the property is less than 200 rupees again, then such matter can be tried summarily. If suppose if the value of the property under section 411 is more than 200 rupees, then such matter cannot be conducted as in summary trial. Or section 414, again knowingly receiving stolen property or disposing stolen property, again the same criteria is that again the value is 200 rupees. Or under section 254 or 256, that is trace clause we have discussed, or section 504 506 of the IPC that we are again, are abetting the above mentioned offences, not all the offences but above mentioned offences. Of course the value should of the amounts, that the amount of the property should be less than 200 rupees. Then all the trial abatement or attempt, so both the aspect has been dealt by this aspect. So section 260 deal with two aspects: which court and which offences. This is most important. Now after this 261, just now we discussed the judicial magistrate second class has the power to deals with the summary trial subject to the punishment of 6 months. Then come to the procedure 262. Frankly speaking, there is no such kind of procedure is followed, but the procedure of the summons case, that is what we have discussed earlier. The procedure of the summons case we have already discussed under section 251 to section 259. The same procedure has to be followed by the court. There is no separate procedure available for the summary trial. This has to be bear in the mind. However, while avoiding the punishment by the court under this summary trial, that is these four categories of the court, the punishment should not be passed, or it should not be more than, very interestingly, 3 months. This is the very interesting aspect. So if you ask me the procedure of the summons trial is the procedure of summary trial. Punishment only, the court cannot award the punishment more than 3 years. I'm sorry, the 3 months. This is the another characteristics of the summary trials. Then come to the keeping of a record. Now, even though it is an administrative functions, it is nothing to do with student, nothing to do with the lawyer. This is just purely administrative work. This is up to the court and the clerk in the court how they have to take the record, how they have to take the keep the record of the summary trials. Because for the summary trial there is a separate register kept in the office of the court, and accordingly by mentioning the number in that particular register, matter is allocated to the court, those who are specially empowered. Now what are the records of the summary trial? That it has to be serial number, but obvious number has to be given to the matter. Second, date of commencement of offence is most important. Now why the date of commission of offence? Because the provisions are provided. Because here, if the offences for which, see, under criminal law there is no bar of limitation, except in some cases. Except in some cases, the limitation is bar. That we'll discuss while discussing the provisions under the CRPC. So here, date of commencement offence is most important. Why? If the offence is barred by the law of limitation, then it cannot be tried by the summary. Therefore, it is most important. Then the date of report of the complaint, because law has provided within what limitation the complaint has to file. The name of the complainant, the time, address of the complainant, the offence which he has committed. Because if the offence is not as provided in section 261 subclause 2, then it will not be tried as a summary trial. Then it has to be recorded the plea, examination of witnesses, then the finding of the court has to be there, and the sentence which the court has been awarded. And then lastly, section 264 deals with the judgment of the matters. Now, in this particular trials, 264 provided that after trying the matter summarily, same the procedure as a summary trial, if the accused does not plead guilty, now this is very interesting, then after taking the evidence, magistrate may, after the recording, either convict the accused person under section 264. Now this conviction or acquittal is again similar to the summons case. This is what the procedure is provided. Now again 265 deals with the language of the judgment, all are aware that the language of the judgment is the language of the court. This is what it should be right. The judgment has to be written in the language of the court. Now, what is this concept called as the language of the court? One has to understand. See, it depends upon the regional language of the state. Lower court, I'm talking about lower courts means the hierarchy of the session up to the session court. The language of the court is the regional language of that particular state. Say for instance, if we talk about the Maharashtra, the regional language of the lower court, that is up to the session court, is Marathi, and in case of the High Court and Supreme Court, there is no concept. It's a language of the court is in English language. So all these aspects are provided. This is very small and very simple procedure is provided. No one is going to be asked the full question on this point, but these are the basic aspects of the summary trials. I hope you understand. Especially 260 is the most important. 260, 261, 263. These are the three sections which are important. That's all for the supervised trial is concerned.